We can't just simply look at a video and say this happened. What about the other judges? There are a number of judges on the thing. So, I mean, what I want to legally understand is that when we start addressing a question under 186, is it just a legal question, or this might, as in this case, entail looking at evidence and then also the veracity of that evidence, the interpretation of that evidence? Are we going to entail that, get into that exercise also?
My lord, the immediate response will be based on two
Bhutto, I want to add one more thing. That can you point out any specific question that is being posed to us in the reference that is to be answered? Specific question for the Supreme Court.
My lord, this honorable court itself has posed...
No, in reference. In reference.
My lord, the reference is before your lordship.
Then we should be confined to that question.
My lord, no, your lordship has now framed questions, but if your lordship is looking at the reference on pages 16 to 18, the questions were framed at that time. But may I read those in a minute? They're here. But in order to answer my lord, Mr. Syed Mansoor Ali Shah's question, my lord, this arose in the context of an appeal before this honorable court, so the issue was open at that time, and it arose in a context where the proceedings had finally concluding in the House of Lords, as it then was called, in the United Kingdom. In the Pinochet case, the House of Lords, again by a narrow majority, had come to the conclusion that Mr. Pinochet needs to be extradited. An issue arose, and your lordship knows that ordinarily the House of Lords never reviews its judgments. Once they have given a judgment, that's final, concluded, and the proceedings were over. But an application was made that Mr. Justice Hoffman, who was one of the members of the majority, his wife was part of the Amnesty International, and Amnesty International had submitted an amicus brief.
That was a review, was it?
My lord, but your lordship knows that unlike in our case in the
that
Constitution
could certainly happen. If we were to decide a matter, somebody could file a review and say that one of the judges had a... So I want to really understand the jurisdiction under 186, that a question of law, as I understand, is that this judgment is wrong. Fair enough. Can we just look at it? Can we then revisit the judgment and say it is wrong, or don't we relying on some extra material now, which you say is the interview, which requires inquiry? Could we just take the interview on the face value, or are we to then find out what the text meant, or are we to, some people need to come forward, do we need to cross-examine, do we need to get into all this, or just take the interview on the face value? And that's just one judge. There are a number of other judges who are not saying anything. Maybe they were not under pressure, or they were, we don't know. So my legal question is, are we to dive into an inquiry? Is that envisaged under 186 is my question.
जैसे जरा सा मैं अपनी तरफ से जरा बात करना चाह रहा हूँ। जो अब आपने बातें की हैं आर्टिकल 4 की, जो आर्टिकल 4 कभी भी ख़त्म नहीं किया जा सकता है, चाहे 233 के तहत भी नहीं किया जा सकता है। आर्टिकल 9 की एक अलग बहस है, मगर अगर आर्टिकल 4 कभी भी ख़त्म नहीं किया जा सकता है, तब ये हम बात क्यों नहीं कर सकते हैं, इस केस को अलग रखें, मगर हर क्रिमिनल केस में जहाँ के प्रोसिक्यूशन में एलिमेंट ऑफ पॉलिटिक्स इन्वॉल्व हो जाए, नेचुरली एक वक्त में जबकि आइन सस्पेंड हुआ है या एब्रोगेट हुआ है, तो हर को क्यों नहीं राइट मिले दोबारा अदालत का रुख करने के लिए कि जी आर्टिकल 4 तो आपने नजरअंदाज ही कर दिया, तो आपने कहा कि सिर्फ और सिर्फ ये हम इस केस को देख सकते हैं, हम सारे ऐसे केसेस को क्यों ना देखें, ठीक है। वहां मगर आर्टिकल 4 को देखने के लिए कि दरवाजा खुलता है या नहीं, मेरे हिसाब से आपको केस में जाना पड़ेगा। आप सिर्फ ये कह सकते हैं तो नहीं है कि जी क्योंकि उस जमाने में माशाअल्लाह लगा हुआ था तो फलां शख्स को फांसी हो गई तो ये अनकॉन्स्टिट्यूशनल हो गया, नहीं। آپ کو تھوڑا سا اور محنت کرنا ہوگی کہ آرٹیکل 4 کا تو آپ کو دروازہ ہے، مگر آرٹیکل 4 کے دروازے کو کھولنے کے لیے آپ کو کچھ ہمیں بنیادی چیزیں دکھانا ہوں گی. یہ ضروری نہیں کہ اسی کیس میں ہو، دوسرے کیس میں بھی ہو سکتا ہے، مگر وہ اب دیکھیں گے اگر صدر صاحب مناسب سمجھیں کہ وہاں بھی ریفرنس بھیجیں، کیونکہ ریویو کا جوریزڈکشن ختم ہو گیا تو فیصلہ تو ختم ہو گیا ہر لحاظ سے، اب رہ گیا صرف اوپینین. تو میں تو کہوں گا کہ اگر آپ کی بات کو ہم آگے لے جائیں اور لاجیکل کنکلوژن پہ لے جائیں تو ہر کیس میں ہم کر سکتے ہیں یہ، اگر نمبر 1 وہ اس وقت میں کانسٹیٹیوشنل ڈپارچر ہو، پہلی بات. دوسری بات یہ کہ آرٹیکل 4 کے آپ پرائما فیسائی کیس آپ اسٹیبلش کر پائیں. تیسری بات پھر یہ ہوگی کہ ٹھیک ہے آرٹیکل پہلی بات بھی ہو گئی، دوسری بات بھی ہو گئی، مگر ہر کیس اس بنیاد پہ نہیں ختم ہو سکتا ہے، اس پہ اوپینین نہیں دیا جا سکتا ہے، مگر اس میں آپ کو کچھ مزید دکھانا ہوگا. وہ مزید دکھانے کے لیے اس کیس میں ایک جج صاحب کا انٹرویو ہے، دوسرے کیس میں شاید کچھ اور ہو سکتا ہے کہ وہ ڈی این اے ایویڈنس آ گئی ہو، فار انسٹنس کہ جو زمانے میں ڈی این اے نہیں ہوتی تھی ڈی این اے ایویڈنس آ گئی ہے. تو یہ آپ اس سے اگری کریں گے یا آپ اس سے ڈس ایگری کریں گے؟
My lord, I would most respectfully agree with it, because I would respectfully submit that this is something which is now happening in the other jurisdictions of the world as well. In some cases, it is happening in the context of the state having recognized that in politically charged cases, injustices can take place which need to be corrected, has itself specifically conferred this authority on the courts of law.
That's fair enough. I mean, I'm for fixing miscarriages of justice whenever they happen. It's happened outside another jurisdiction. Miscarriage of justice needs to be fixed. There's no doubt about that. My question right now is the jurisdiction this court enjoys to do that. You know, to understand that. The review is done with, so we don't have any judicial remedy available. So just want to understand whether the window 186 provides is there to fix a miscarriage of justice through an opinion. Is that possible? Because that miscarriage of justice requires probing into the matter, which could be, I mean, you could argue that 186 does include probing into the matter. So that, I want to understand the window, the door that is to be used for the purpose of fixing miscarriage of justice.
If I may just add to my learned brother's thing, I don't think even if we were to come up with a different opinion, there is no question of fixing anything. Now it is only a question of posterity and history. You can't fix anything because the sentence has been carried out. So you can't possibly fix it. So at the moment, all we are faced with is, do you want, as it has been said, do you want this to be used as a precedent in the future? Probably we can give an opinion on that. We can say yes, no, or whatever else we may hear. So fixing part is over. I mean, if the person was alive, that would have been a different scenario. So that scenario is not before us anymore. So even if we were to come to the conclusion that this was miscarriage of justice, we cannot fix it. So the judgment has come, the review has come, that's over. Now we are more concerned with the repute of a person, posterity, history, and whether it constitutes a good precedent for courts to apply. I think probably we can restrict ourselves, and that's the only thing we can really do.
My lord,
Mr. Mahdood, let me add to that also, because there's another question that arises in this.
My lord.
The sole plank on which this case rests is that at that time the judiciary was not independent. It was under pressure. This is the sole plank. There is no other argument. The argument is you could establish that the judiciary was not independent, this judgment goes. Now, how do we go about establishing that fact? And the exercise involved in establishing that fact requires inquiry into the matter, because there is no other argument. The only argument, Article 4 is violated because judges at that time were not independent, allegedly as said. So how do we entail this? How do you get into this exercise that the bench was not independent?
My lord, may I?
Let us not generalize the issue of judiciary being not independent at that time. There were honorable judges sitting at the bench at that time. There, the issue is only restricted to one judge who then came out and he made a statement. So let's not generalize and
If that is the case, that if it's only one judge, then the question is, how does that matter if the rest of the judges we have know nothing on? So how many judges are we talking about? If one judge went astray, then what
I think one judge would.
That too requires some inquiry, whether at all this pressure, what does it really mean by this pressure?
Khan Sahab, dekhiye, if it was unanimous court or a larger court, one judge would not matter. But if it is the judgment of acquittal and conviction stood on one judge, then I think one judge would matter. And this does not suggest that the other judges were not independent. Let's assume they were all independent, but one judge has categorically come forward and said something. Now, we don't need to enter into the realm of was this actually in an interview, because long after the interview came, broadcast on public national television, he could have said, this interview is doctored, this is not my interview, this is not me, my picture was put, or whatever. That has not happened. And he survived a great number of years after that. So one judge, I think, does matter in this case. There may be other cases, okay, you'll say, okay, one more vote goes out, what difference it would make? Nothing. But here it hung by a thread of one vote. It did matter, I think. That's, if it was 4, it would have gone the other way, acquittal, as simple as that.
My
I
Lord,
can't see any other result.
My Lord, there have been a number of questions by your Lordships. May I
Can we at this juncture see the thing now, because
Yes, Your
I
Lordship.
believe it's ready, or you want to continue
I
with
just
your
want
thought?
to, my Lord, no, I'll answer your Lordship's questions. I have noted them all down. After that, if your Lordship so pleases, or now, as your Lordship pleases.
لگا دیں وہ بڑی اسکرین پہ نہیں لگ رہا ہے. You will have to make do with the smaller screen. Can you just turn one a bit that way so everybody can see it? We can see the one and you can volume دے دیں.
کافی بڑا انٹرویو
جس کو پیدا ہوئے چیف جسٹس اپریل کا مہینہ ڈاکٹر صاحب کی زندگی میں بڑی اہمیت کا حامل ہے. ڈاکٹر صاحب سے ہم گفتگو کرتے ہیں.
اور تیز ہو سکتا ہے
تھا کہ ہائی کورٹ کے بیرونی جو دیوار ہے, لوگ اس کے ساتھ گزرتے ہوئے بھی بڑے احتیاط سے گزرتے تھے کہ اندر جج بیٹھے ہیں, اندر بڑے لوگ بیٹھے ہیں, وہ لوگ بیٹھے ہیں جو بڑے فیصلے کرنے والے ہیں. اور آج اسی بلڈنگ میں گیٹ سے ایک آدمی موٹر سائیکل پہ داخل ہوتا ہے, ہارن بجاتا ہے, وہ دوسرے گیٹ سے نکل جاتا ہے. تو یہ جو صورتحال پیدا ہوئی, یہ کیا ہے؟
یہ تو میرے خیال میں آج کل کا زمانہ ہے جس میں کوئی کسی کی بھی زیادہ رسپیکٹ نہیں ہے. باقی جج تو وہی ہیں بیچارے, اسی طرح محنت کر رہے ہیں, اسی طرح ایمانداری سے ہی کام کرتے ہیں, لیکن لوگوں کو ان کے بارے میں کچھ شبہات ہیں, شکوک ہیں, حالانکہ میرے خیال میں جسٹیفائڈ نہیں ہے. تو باقی یہ جو آپ کہتے ہیں کہ وہ احترام اتنا نہیں رہا, یہ تو میرے خیال میں یہ سوسائٹی میں سارے محکموں میں, سارے اداروں میں, ہر جگہ بس لوگ جو ہیں وہ بہت ہی مادر پدر آزاد ہو گئے ہیں.
لوگوں کا یہ خیال کیوں ہو گیا ہے کہ ان کو انصاف نہیں مل رہا؟ کسی سطح پر لوگوں کو اگر انصاف نہیں ملنے کا یہ تاثر ہے, تو کیا اس تاثر کو ختم کرنا جوڈیشری کا کام نہیں؟
یہاں کام تو جوڈیشری کا ہے, مگر وہ مجھے سمجھ نہیں آتا کیسے کریں. ایمانداری سے کام کر رہے ہیں, محنت سے کام کر رہے ہیں, صحیح کام کر رہے ہیں, تو پھر بھی تاثر رہتا ہے. یہ زیادہ سیاسی مقدمات کی وجہ سے ہے. جب وہ کوئی ایسا کیس آ جاتا ہے جس میں گورنمنٹ انوالو ہوتی ہے, یا اسمبلی کو توڑ دی جاتی ہے, یا کوئی پرائم منسٹر کے خلاف کوئی ایکشن ہوتا ہے, تو وہ ان معاملات میں شاید جوڈیشری نے اتنی تنہی اور اتنی انڈیپینڈنس سے شاید کام نہیں لیا جتنا کہ لوگوں کے توقعات تھی. اس کی وجہ سے یہ میرے خیال میں یہ زیادہ امپریشن ہوا ہے.
شاہ صاحب, یہ کتنی, کیا آپ اس کو افسوسناک بات نہیں سمجھتے کہ لوگ کہتے ہیں کہ وکیل کی بجائے جج کر لیا جائے؟
نہیں, یہ تو لوگ تو کہتے ہیں, مگر میرے خیال میں یہ زیادتی ہے اور یہ بالکل غلط بات ہے. ججز ابھی بھی محنت سے کام کر رہے ہیں, ابھی بھی وہ بالکل صحیح فیصلے کرنے کی کوشش کرتے ہیں. اب لوگوں کو تو کوئی روک نہیں سکتا, کیونکہ لوگ لوگ آج کل بہت ہی، جیسے میں نے کہا، مادر پدر آزاد ہوئے ہیں. ہر ایک چاہتا ہے کہ فیصلہ اسی کے حق میں ہو. اگر اس کے حق میں نہ ہو، وہ سمجھتا ہے کہ جج دوسری طرف ملا ہوا ہے.
عوام سے آپ کیا کہنا پسند کریں گے یہاں پہ کہ وہ کیسے، ان کا اعتماد کیسے بحال ہو؟ یہ صرف سیاسی فیصلوں کی بات نہیں ہے. لوگوں کو جب لیٹیگیشن میں جانا پڑتا ہے، جب لوگ کسی ظلم کے خلاف، کسی ناانصافی کے خلاف، کسی غیر قانونی چیز کے خلاف عدالت میں، کسی بھی عدالت میں جاتے ہیں اور وہاں پہ وہ اگر پٹیشن دائر کرتے ہیں تو انصاف اس حد تک دیر سے ملتا ہے کہ انصاف کا مقصد ہی ختم ہو جاتا ہے.
یہ تو ہم نے دو باتیں کی. ایک کو ڈیلیز کی بات کی کہ اتنا تاخیر سے ملتا ہے کہ وہ جو ہے اس کا مقصد ہی فوت ہو جاتا ہے. اس میں تو اور عوامل ہیں، مگر یہ کہ ان ججز جو ہے ایمانداری سے کام نہیں کرتے، یہ ایک دوسری بات ہے. میں سمجھتا ہوں کہ یہ جو ڈیلیز ہو رہی ہے وہ اس لیے ہے کہ ججز کم ہیں، کام بے شمار ہے. آپ دیکھیں گے ہر ایک ہائی کورٹ کے جج کے پاس تقریباً 40 مقدمے روز ہوتے ہیں. اگر آپ کسی یورپین کنٹری میں جائیں تو 40 مقدمے وہ سارے مہینے میں نہیں طے کرتے.
کس نے روکا ہے کہ ججز نہ زیادہ رکھیں؟ مطلب کوئی ایسی پابندی ہے کہ ججز زیادہ نہ رکھے جائیں؟
نہیں، میرے خیال میں وہ حالات ہے نا، یعنی کہ جج کی
ریلیونٹ وہاں سے
بتا سکیں گے
یعنی کافی وہ تنخواہیں بھی کافی ہیں.
وہ منٹس آپ کو پتہ ہے کہاں سے؟
تو بہت ساری باتیں ہو رہی ہیں. ریلیونٹ کتنے دیر بعد آئے گا؟
میں نے آپ سے عرض کیا جو میں نے فائل کی ہے نا،
یعنی کس نمبر پہ آئے گا؟ کچھ آپ کو پتا ہے؟ 5 منٹ بعد، 10 منٹ بعد؟
یہ پوری تو میں نے نہیں دیکھی ہوئی. پوری جو ویڈیو جو ابھی جیو نے دی ہے،
ڈیوریشن بتا دیجیے نا آپ کتنے منٹس کے بعد ہے تو اس کو آگے کر لیتے نا.
جو پورشن آپ کو آپ کے سمجھتے ہیں فیور میں، وہ کب آتا ہے آپ کو پتا ہے یا نہیں؟
اس میں نے جو آپ خود فائل کی ہوئی ہے
اس کا بتا دیں.
اس میں مشکل ہوگا مجھے بتانا.
آپ کی یو ایس بی میں ہے؟
جی ہاں، جو میری یو ایس بی میں ہے نا، میری یو ایس بی آپ چلا لینا. وہ
پرٹیکولر یو ایس بی ہے سر، اس کو لگوا لیں جو ان کی ہے.
اس کے اندر پرٹیکولر جو میں نے یو ایس بی فائل کی ہوئی
دے دیں، آپ نکال کے دیں یو ایس بی.
میں نے دی ہوئی ہیں سر. کیا کہتے ہیں
یہ یو ایس بی لگا
یہ ڈائریکٹ ہو جائے گا نا.
Constitution, law and Pakistan affairs must be placed before this court, and that is a book written by him. He has explained all these matters in details, in writing.
Suri sir, we definitely hear you. Abhi we are just trying to.
That book should be placed before all the judges, and
وہ آپ نے بتا دیجیے
page 182 onwards.
آپ نے فائل کی ہوئی ہے
جی
آپ نے فائل؟
میں نے ایکسٹریکٹ لگائے اپنے
سی ایم اے نمبر.
یہ آپ دیکھیے میرا یہ ہے 5788.
ایک سیکنڈ.
وہ کتاب پہلے کی ہے یا انٹرویو پہلے کا ہے؟
نہیں، کتاب کا نام بتائیں.
کتاب کا نام ہے جی کانسٹیٹیوشن، لا اینڈ پاکستان افیئرس، written by چیف جسٹس ڈاکٹر سید نسیم حسن شاہ.
یہ انٹرویو ان کا بات کا ہے یا کتاب پہلے کی ہے قصوری صاحب؟
جی
انٹرویو بات کا ہے یا کتاب بات کی ہے؟ پہلے کون سی چیز آئی؟
I wish I could give a positive answer, but this is his written statement, and in my
انٹرویو کی ڈیٹ کیا ہے کسی کو پتا ہے؟
اس میں اندازاً آفٹر 22 منٹس جو میں نے ابھی
انٹرویو کی ڈیٹ کیا ہے
کسی سر
جو چل رہا ہے انٹرویو؟ یہ کب کا انٹرویو ہے؟
یہ جو ہم نے دیکھا یہ کب انٹرویو لیا گیا تھا؟
سر آفٹر دی ڈیٹ سر ابھی مجھے
3/12/2003.
یہ اس میں اس کے خط میں کیا لکھتے ہیں؟
یہ بک کب پبلش ہوئی ہے؟
یہ میرا جو ریٹن رپلائی ہے اس کے پیجز ہیں سر 42.
نہیں، یہ انٹرویو
42 سے لے کے
3/12/2003 کا. اچھا یہ نوٹ کر لیں ڈیٹ. یہ جو انٹرویو ہے 3/12/2003 کا، ٹھیک ہے. وہ جب وہ تیار ہو جائے بتائیے. تیار ہے؟ اسی کاپی کیوں کر رہے ہیں؟ اچھا اوکے. اچھا آپ کون سی چیز بتا رہے تھے قصوری صاحب؟
پیجز ہیں.
نہیں نمبر بتائیں پہلے اوپر. آپ کا سی ایم اے کا نمبر کیا ہے؟
یہ میرا نمبر ہے جی اپنا سی ایم اے نمبر.
یہ نکالیے ذرا.
57 5788 or 2001,
5788/2001,
which I filed before this honorable court on 31st of December 2011.
جب تک وہ نکال رہے ہیں ہم یہ دیکھ لیتے ہیں.
And the extracts of the book are mentioned in my rejoinder from page 42 to page 57.
اس میں تو نہیں تو مارکیٹ 5788 اس میں ہوگا.
ادھر دیکھیے اس بنڈل میں، اس میں تو نہیں ہے.
My lord will read this.
اس لیے میں 5788 کی بات کر رہے ہیں.
جی in my rejoinder from pages 42 to 57. These are all the extracts which I have collected from the book of late Chief Justice
یہ تھی نا لاسٹ ٹائم کی، وہ کہاں ہے بک؟
یہ والی جس اوپن والا.
اچھا یہ
بات سنیں
جی،
یہ یو ایس بی جو ہے نا
and that's very important, sir, because that will
42
wash away all this interview etc.
42. اس کتاب کا پہلا پیج تو میں بتا دیں نا، کس کی کتاب ہے، کون مصنف ہے، کچھ تو بتائیں نا.
مصنف اس کے جی ڈاکٹر صاحب ہیں.
پہلا پیج لگا دیا کریں نا. چلیں پیج 42 پہ کیا پڑھنا چاہ رہے ہیں پڑھیں. پڑھیے پیج 42 پہ آپ پڑھیے.
میں بڑا لمبا چوڑا ہے، میں
ریلیونٹ آپ کیا پڑھنا چاہ رہے ہیں ہمیں بتائیے نا. ریلیونٹ چیز
تو جی 42 پر لاسٹ 3 lines.
This is my view. یہاں سے پڑھنا چاہ رہے
In
ہیں.
my view, that judges do not have a crystal ball to look into the future. We must determine a matter in the circumstances submitted before us and leave to the history to judge whether correct decision was taken.
What does this mean? ایسی ریلیونٹ باتیں بتائیں نا.
آگے آ جائیے جی. میں آتا ہوں جی.
46 پیج پہ آپ نے کچھ مارکنگ کی ہوئی ہے. 186 ہے اس کا ٹائپ پیج.
یہ دیکھیں یہاں پیج جیسے پیج 56. The proposal, may I read? This is 6th line from the top. Page 56 of my rejoinder. Page. This is page. یہ کتاب کا پیج.
اس نے کہا کہ مجھ سے انسان ہے کمزور ہے.
53 Mr. Kasuri, if you have, don't please stand here and look for the page. آپ آرام سے بیٹھیے. If the relevant page is, just tell us. Otherwise we'll waste a lot of time just looking for what you want to read. آپ آرام سے بیٹھیے and let us know what page you want us to read.
I'll read the relevant portion, sir.
I don't want you to read the whole book. Just tell us what particular paragraph, page you want to read.
میں وہی بتا رہا ہوں جی.
بتائیے جی.
تو یہ ہے اپنا پیج 52 آف مائی پیپر بک.
جی پڑھیے، کہاں سے پڑھنا چاہ رہے ہیں؟
یہ ہے 1 2 3 8th line from the bottom, 8th or 9th line.
پڑھیے.
I told Justice Dora Patel that finding Mr. Bhutto not guilty was not consistent with the thinking of the four Punjab judges, since since all of them had come to the conclusion that the evidence in the High Court of the officials of the Federal Security Force who had participated in the killing proved their guilt. And these officials had no motive of their own against Ahmad Raza Kasuri. Undoubtedly, it was only the wish of Bhutto which they had carried out.
What do you want to show from this? How does this language come undoubtedly? It could be the wish of 101 other persons also. So what do you want to show us from it?
I'm coming to gradually see. Let's
उस ज़ुबानी बता दें क्या कहना क्या चाहते हैं, तो मकसद
ये है जी अपनी पेज 53. Page 53. Last from the bottom, ninth line. While the majority judgment was written in the name of name of Inal Haq CJ, in fact it was collective effort of all the four judges who had found Mr. Bhutto to be guilty. Chief Justice had assigned various issues in the case for being dealt with by his colleague, and we had written our portions of the judgment and delivered it to the Chief Justice. The majority judges was therefore a collective effort wherein Chief Justice had merged all the portions into one consistent whole after appropriate vetting. अब उन्होंने कहा कि चीफ जस्टिस ने हमें
no English language, you don't have to translate it.
हमें बांट दिया, हमने
We understand the English.
The position is कि अगर इनको pressure थे, he should have recused himself. He should have recused himself.
Don't give us that advice. That is irrelevant.
No. See, position यहाँ ये है कि वो
you saying that this helps you or doesn't help you?
This is a very voluminous case. उन्होंने 4 portions में दे दिया और हम सब ने अपने जजमेंट लिखे और उसको चीफ जस्टिस ने उनको कंसोलिडेट कर दिया उसी. That's what he's saying.
फिर क्या होगा? फिर क्या होगा?
So he is a party to it.
ठीक है.
He is a party to it.
That is recorded in the judgment itself. He's a party to it.
He's a party to it. So therefore,
Mr. Kasuri, make the point, please.
मेरा point ये है कि sir, if at all there was any pressure, he should recuse himself.
We've noted that point.
Then there's another argument. Who is the author judge in this? That is the Chief Justice of Pakistan. Now, if he had decided on pressure, that means that he served General Zia and taken the throne from his side. Now, what history tells us?
Are you going to make the point or not?
My point was, history tells us that after few months later, PCO was promulgated and Chief Justice refused to take oath. A judge who refused to take oath and go on a premature retirement, do you think on the instructions of or on the pressure of somebody he will go and pass a judgment of death? That's the point.
Now can we continue? आप तशरीफ रखें. This is not your reference, this is the presidential reference. So you don't have a right of audience to begin with. You will be heard at your appropriate time. So अगर आप हर दफा में interrupt करेंगे तो हम please जरा ठहर जाइए. This is not a case. This is not an adversarial proceedings.
जवाब दिया उसकी भी कॉपी मुझे देनी चाहिए. I should be provided with the copy which Mr. Bilawal Bhutto has placed before this court.
Yes, it's been filed. दे दीजिए इनको सेट अगर नहीं है एक्स्ट्रा आपके पास पड़ा हुआ है. आप ये काम इनसे कहिए ना, हमसे तो ना कहिए. हमसे ऑफिस का काम ना करवाएं. अगर कोई मसला हो रहा है नहीं मिल रही फिर हमें बता दें, हम आपको दिलवा देंगे. अच्छा वो हो गई जगह. हाँ चलें लगाएं. This is not the same book.
These are 3 different books. لیکن یہ والا پیج اس میں نہیں, وہ میموائرز ہے. لیکن that paragraph, page 53 is a relevant paragraph, which is collective.
SB کا چلے گا.
لکھی تھی, یہ تو نہیں تھا کہ وکیل نے اپنی ججمنٹ لکھا تھا میں روٹ کہتا ہوں.
معلومات کیجیے کہ مسئلہ ہے تو بعد میں سن کر لیتے ہیں. چلیں وہ کون تھے ادھر؟ ہاں چل گیا.
جج صاحبان کیا کریں آپ کی ایک آبزرویشن.
جی ہاں, یہ میرے خیال میں بالکل حقیقت پہ مبنی ہے.
کسو کتاب ہے یہ آپ کے ریویوز کے بارے میں, ضرورت کا پیکر. آپ نے کہا کوئی آ جاتا ہے کہ جناب ماشاء اللہ غیر قانونی ہے, انہوں نے آئین کی خلاف ورزی کی ہے, آئین کو توڑ دیا ہے, لہذا آپ ماشاء اللہ کو غیر قانونی قرار دیں, اور انہوں نے جو کارروائی کی ہے اس کی انہیں سزا دیں. جج صاحبان بیٹھے ہیں اوپر مارشل لا والے توپیں بندوقیں لے کے کھڑے ہیں, تو پھر جج صاحبان کیا کریں آپ کی ایک آبزرویشن.
جی ہاں, یہ میرے خیال میں بالکل حقیقت پہ مبنی ہے کہ لوگوں کا تو خیال ہے نا کہ ججز کو تلواریں چلانی چاہیے اور ملٹری والوں کو یعنی نیست و نابود کر دینا چاہیے, انہوں نے غلط کیا ہے. مگر وہ ملٹری والے ہیں, وہ ججوں کو نکال سکتے ہیں. اور دوسرا یہ ہے کہ لوگ بالکل کچھ کرتے نہیں جب تک پبلک اوپینین نہ ہو. وہ کوئی بھی کورٹ یا کوئی بھی ادارہ اپنے پورا
طرح سے ایک بات کہنا چاہیے کہ جج پر یہ لازم نہیں کہ جج انصاف کرے.
لازم تو ہے, مگر کئی دفعہ اپنی جب یعنی نوکری کا مسئلہ آتا ہے تو تمام جج صاحبان جو ہیں وہ اتنے بہادر نہیں ہوتے کہ اپنی نوکریوں کو قربان کر دیں اور انصاف کرتے رہیں. میں آپ کو سچی بات بتا رہا ہوں, لہٰذا وہ یہی سمجھتے ہیں کہ اپنی نوکری کو بچا لینا چاہیے, کیونکہ شاید میرا یہاں رہنا قوم کے لیے اور اس ادارے کے لیے بہتر رہے گا. کیونکہ اگر میں نے نکال دیا اور میری جگہ کوئی ایسے کوئی آ گیا تو وہ جو بھی فوجی کہیں گے وہ کرتا رہے گا. تو لہذا بہتر ہے کہ ایک آدھ کیس میں جس میں فوج زیادہ انٹرسٹڈ ہے اس میں کوئی تھوڑا سی لچک دکھا دی جائے, مگر یعنی اپنی سیٹ بچا لی.
تحریر کیا یہ آپ
جی, یہ بس آپ نے تو یہ دیا ہے. پورشن آپ نے یہ تو نہیں غلط والا بتایا میں.
یہی جو انٹرویو دیا,
تمام جج صاحبان جو ہیں وہ اتنے بہادر نہیں ہوتے کہ اپنی نوکریوں کو قربان کر دیں اور انصاف کرتے ہیں. میں آپ کو سچی بات بتا رہا ہوں, لہٰذا وہ یہی سمجھتے ہیں کہ اپنی نوکری کو بچا لینا چاہیے, کیونکہ شاید میرا یہاں رہنا قوم کے لیے اور اس ادارے کے لیے بہتر رہے گا. کیونکہ اگر میں نے نکال دیا اور میری جگہ کوئی ایسے کوئی آ گیا تو وہ جو بھی فوجی کہیں گے وہ کرتا رہے گا. تو لہذا بہتر ہے کہ ایک آدھ کیس میں جس میں فوج زیادہ انٹرسٹڈ ہے اس میں کوئی تھوڑا سی لچک دکھا دی جائے, مگر یعنی اپنی سیٹ بچا لی.
بھٹو کیس میں موجود تھے.
جی,
آپ سے اگر یہ پوچھا جائے کہ کیا پاکستان کی عدالتی تاریخ میں ایسی کوئی مثال ہے کہ محض مشورے کی بنیاد پر کسی کو پھانسی دی گئی ہے؟
جی ہاں, میرے خیال میں یہ مشورہ تو نہیں تھا, اس میں تو وہ تھا کہ ان کا آرڈر تھا کہ وہ یعنی اپنے یعنی سبارڈینیٹس کو اس کو رضا قصوری کو ختم کر دیا جائے. تو لہذا مشورے کی اور بات ہوتی ہے, آرڈر کی اور بات.
صاحب یہ جو جب میں اگر میں مجرم ہوں, میں ایکیوز ہوں, میں کہوں کہ مجھے آپ پر اعتبار نہیں ہے, مجھے آپ سے انصاف کی توقع نہیں ہے, تو آپ کو بطور جج जज क्या करना चाहिए?
ये डिपेंड करेगा ना कि क्या आप देखते हैं वजूहात।
मुल्क का वजीर आजम हूँ, आपके सामने पेश हूँ, मैंने आपको प्रमोशन नहीं दी, आपको बिठा दिया गया, मैं कहता हूँ मुझे आपसे इंसाफ की तवक्को नहीं है, तो आपको क्या करना चाहिए था?
तो मैंने नहीं ख्याल किसी को उन्होंने कहा ऐसी बात कि आप मुझे तवक्को नहीं, बल्कि उन्होंने तो बड़ा हमेशा कहा है कि मुझे सुप्रीम कोर्ट पे पूरी।
मौलवी मुश्ताक साहब की मैं बात कर रहा हूँ, मौलवी मुश्ताक साहब को जुल्फ़िकार अली भुट्टो ने ये कहा।
जी हाँ, वो मेरे ख्याल में मौलवी साहब की रियासती।
That's it.
You've not even given the correct recording.
Sir,
There is more.
it was removed from the YouTube.
नहीं, please show us. ऐसे तो ना करें, because this is not even relevant. The one portion, I don't know if it's correct or not. अब हम अपने तौर पे सुन लेंगे. Let's continue with Mr. मखदूम अली खान.
है इसके आगे काफी है जो भी।
Yes sir, देखें वो जो है ना, मैं आप सर्च करूँ ना जो।
The question of pressure is a portion which you've not produced in it.
मैं अर्ज करूँ ना, ये जो
अर्ज क्या करना है ना, factually आप हमें वो गलत चीज दे रहे हैं.
नहीं सर, देखें जो YouTube पर जो मेन इंटरव्यू था वो रिमूव कर दिया गया था. हमारे पास अब उसकी कॉपी नहीं है. What we could get, we have given.
Geo has sent the whole copy.
सर हमें कॉपी नहीं मिली है ना सर, प्लीज.
अच्छा ऐसा करें, आप ऐसा करें कि नहीं, एक सेकंड ठहर जाइए. ये जो जियो वाली कॉपी है, इसकी कॉपी बना लें 2-4, ये जो आई है जियो से, ठीक है. और फिर हमें ये अभी 1 घंटा तो हमारे पास नहीं है सारे को सुने. जो रेलिवेंट पोर्शन है आप हमें ये बता देंगे 10 मिनट पे, 20 मिनट पे, जो भी मिनट पे, वो हम नेक्स्ट डेट पे कर लेंगे. नेक्स्ट डेट पे कर लेंगे. आज आप ले जाइएगा. प्लीज हियर इट केयरफुली एंड गिव अस एग्जैक्ट टाइम लाइन. नेक्स्ट आइए मखदूम साहब.
That will be done, sir. Thank you.
जी.
My Lord, may I, with your Lordship's leave, begin with the questions? I have noted the questions at that time. My Lord, Mr. Syed Mansoor Ali Shah asked the first question, what is the window available to us in this case? My respectful submission would be that the window is the window of the principle of nemo iudex, that whether the acted in accordance with the due process of law, or were there any external pressures. When your Lordship sees that interview, whether that window is open or not will become apparent. My respectful submission.
Other than the interview, you don't have to say anything else?
My Lord, yes. The other is, your Lordship said what can be fixed, my Lord the Chief Justice. Your Lordship said the sentence has been executed. And your Lordship said what is to be fixed. My Lord, your Lordship is right, that cannot be fixed. But what can be fixed, as your Lordship identified for the purpose of posterity and history, is the precedent of this Honorable Court, the jurisprudence of this Honorable Court, and of course the reputational damage which will continue for all times to the accused and his family. So that still remains.
Reputational damage of the Supreme Court or reputational damage to the heirs of the deceased?
My Lord, reputational damage with great respect to that of the Supreme Court as well as the deceased.
Please expand.
My Lord, over a period of time, and I'll show to your Lordship that these considerations are relevant. Several writers writing books, journalists, history, interviews of judges, the kind of letter that your Lordship saw, all indicate that this was an unsafe conviction. As I proceed further, I'll show to your Lordship from precedents from other jurisdictions.
Will we benefit by opening old wounds, or we will suffer?
My Lord, my submission is that...
Court I'm talking in particular.
Yes, my Lord. My submission is that once this presidential reference is here, if your Lordship takes the view that this was a miscarriage of justice and fixes it at least for the purposes of posterity, the reputation is enhanced, not diminished. Your Lordship has done that.
Who would be at fault, the Supreme Court or the prosecutor, the martial law administrator of the time?
My Lord, there are cases at times when it is difficult to say who is at fault. I had the honor on behalf of the International Commission of Jurists to attend a trial in Malaysia where the Bar Council was being charged with contempt because Your Lordship remembers there's an infamous episode in their history as well where the Chief Justice was removed and 4 judges who sought to protect the Chief Justice were also then removed. The Learned Counsel appearing for the Bar Council at that time said that, sir, this is one of those cases where all of us on trial here. So this is a case where society as such, lawyers, judges, politicians, people in power at that authority, all of them had their respective role to play, and this honorable court, with the benefit of hindsight, can fix that error. My Lord,
whether this judgment has been cited anywhere in Pakistan, in any court of law, this judgment has been cited,
my Lord,
as a precedent.
I conducted a quick precedent search. On the next date of hearing, I'll give your Lordship a chart as well. I could not find a judgment where this has been cited with approval to uphold the conviction of an accused.
Which means it has already been discarded. In a manner it has been discarded. It has not been believed by the court.
My Lord, dilutions take place, as last week Your Lordship was hearing a case, Your Lordship have noticed, and they take place in both ways. Your Lordship saw that in the case of Ishaq Khan Khakwani, a learned judge expressed a view that this entire article of the Constitution was illusory in nature, was more inspirational. In Muhammad Nawaz Sharif's case in Panama 1, that very same judge, first as part of a dissent and then as part of a unanimous court, walked away from that precedent, and he said this was only to point out what the legislature could do, and as a judge I will have to implement it. My Lord, Your Lordship have seen it happen in the other way as well, that in a 5-member bench an author judge took a view in Samiullah Baloch, and then in a series of judgment, then he diluted its effects.
What's the relevance of these cases?
My Lord, that your Lordships have distanced yourself from a particular jurisprudence. In response to my Lord Mr. Justice Mandukhel's question.
If at all, in our opinion, we will touch the judgment.
My Lord?
We will touch the judgment.
My Lord, your Lordships don't have to.
It remains as it is.
My Lord, that judgment has been executed.
Yes.
That the sentence has been carried out. That person is no longer alive. What we are here to fix, if your Lordships so consider appropriate, is 1, the jurisprudence of this honorable court, and 2, the reputational damage to the family of the accused.
To the reputational damage, or can we override that sentence that has attained finality?
My Lord, your sentences...
Also come, the doctrine of finality will also come because 3 stages have passed. Original, appellate and the review jurisdiction.
My Lord, sentences, even when your Lordships are hearing an appeal, are never reversed, in the sense that a person may have undergone a number of years of imprisonment. Your Lordship can't restore his liberty to him.
And there is also
but convictions can be set aside.
Conviction
can be set aside.
We also undergone, so there are 3 dimensions of the criminal cases.
For setting aside the conviction, we will have to touch the merits of the case.
Your Ladyship,
after 45 years.
If a conviction is reversed on the ground, or a different view is taken about that conviction, or an opinion is expressed about a conviction that it was unsafe, and therefore it ought not to have been, that order ought not to have been passed, that is enough. Your Ladyship doesn't have to go any further.
Under reference can we do this, because there is no curative jurisdiction in our constitution?
My Lord, your Lordships have done that through a number of windows, which takes me back to my Lord Mr. Sayyid Mansoor Ali Shah's question. Your Lordship recently in Ricotic case, where a statute was under examination before your Lordship, with certain reservations, moved away from the earlier judgment of this honorable court in the Ricotic case, realizing the financial damage it has caused to the country. In a case where my Lord Mr. Sayyid Mansoor Ali Shah dissented, this honorable court dismissed the review petition but under Article 184(3) revisited its earlier order. Your Lordship dissented, I know, but the majority took a different view. In the judge's pensionary benefits case, the review had also been dismissed. But your Lordship said under 184(3).
I might not agree with that, but that's all happening within the jurisdictions that we enjoy.
Yes.
So we're talking about 186 as a policy, then we're saying that President tomorrow would send another reference saying a particular decision is not correct. In order to establish miscarriage of justice, we'll have to delve deep into the facts of the case and then say, yes, it was not rightly decided. So what's the finality given to judgments? You see, the question is, I'm all for the miscarriage issue, but the question is, does our constitution allow that? Can we get into it and tomorrow revisit our judgments through the presidential reference and upset their finality? Because in order to do that, you'll have to go down. Other than the fact that the judge said or did not say anything about pressure, then we'll have to go and see the merits of the case itself. Maybe he might or might not be under pressure, but the merits might say otherwise. So, aap visit to kar rahe na sara factual dispute. How is that possible?
Sir, not the evidence and not the facts, but my submission is that if on the basis of the material on the record, your Lordship reaches the conclusion that this was a case where the effect was that judges have acted under or even one judge has acted under bias, your Lordship will take a different view of the conviction. To give your Lordship a direct example, Pinochet 1 was the 3-2 judgment of the House of Lords. There was only established in the case of one judge, not in the case of all three, that he may have an interest. But on that basis, the entire judgment was overturned. Why was it overturned?
They overturned the judgment in review, perhaps in review jurisdiction.
No, there was no review.
What is their procedure to deal with that?
An application was made that bias unravels all. And because this particular judge's wife was a part of Amnesty International, and Amnesty International had filed an amicus brief in that case, arguing that Pinochet should be extradited.
That's why we want to know what was the nature of their jurisdiction in which such type of powers have been exercised.
An application by the party, my lord, the same kind that where your Lordship interferes if it is said a judgment is infected by fraud or bias. Same jurisdiction. Your Lordship have done that in the case of Asif Ali Zardari's case. I don't point that out right now for the simple reason that that was done under Article 185 of the Constitution, where the judgment of the High Court was appealed from before this Honorable Court. But without going into the facts, without going into the evidence, your Lordship had said that because this was a case where a particular bench was pursuing a particular case, therefore it renders the verdict unsafe.
There were some personal biases.
And therefore your Lordship did not sort of record a finding of acquittal. Your Lordship sent the case back, but your Lordship said this order is unsafe to uphold.
Mr. Makhdoom Ali Khan, can you read Article 189?
My lord, yes.
And maybe we can find a solution here. Article 189.
My lord, any decision of the Supreme Court shall, to the extent that it decides a question of law or is based upon or enunciates a principle of law, be binding on all other courts in Pakistan.
Today, this judgment is binding on all courts in Pakistan.
My lord, yes.
Now we take you to the order of this court dated 21st of April 2011. Do you have that order?
Lord, I'll find it.
21st of April 2011.
2011.
21st of April 2011. It's a reported order as well, I'm told. दे दें उनको, दे दें.
ये मिल गया.
ये ले ले, reported है. So can you read the second question?
whether the conviction leading to execution of Shahid Zulfikar Ali Bhutto could be termed as a decision of the Supreme Court binding on all other courts, being based upon or enunciating the principle of law in terms of Article 189 of the Constitution of the Islamic Republic of Pakistan, if not, its effect and consequences.
Why can't we do this?
That is a question.
Because at the moment, for instance, tomorrow an application is submitted to the High Court that conduct the trial in the High Court. Evidence of approval be accepted. So we, for the guidance of the subordinate courts and the High Court, can we not, in this question number 2 that was framed by this court, at least give an opinion on that and nothing else? Whether we consider it, I mean, everybody is saying it's not good law, nobody cites it, but one session judge can pick up the judgment and say this is a judgment of the Supreme Court and I'm going to follow it. And he will be perfectly constitutionally and legally correct in doing so. In fact, it's binding on him under Article 189. Does this open a window for opportunity or it doesn't? The second question.
It does, my lord, in terms of a question of law which was decided by the court. But it may be.
Though we are not giving any relief,
yes,
but we are saying that, okay, I don't think this is good precedent. It's per incurium, or whichever language we want to use. And if you read now the first question of the same order,
whether the decision of the Lahore High Court as well as the Supreme Court of Pakistan in the murder trial against Shahid Zulfikar Ali Bhutto meets the requirement of fundamental rights as guaranteed under Article 4, sub-articles 1 and 2A, Article 8, Article 9, Article 10A, due process, Article 14, Article 25 of the Constitution of the Islamic Republic of Pakistan, 1973. If it does not, its effect and consequences.
The second question is a general question.
My lord, yes.
It's a question, is this good law? And at least judgments of the Supreme Court are not binding on this bench to the extent Article 189 says on all other courts.
Yes.
Of course, if it's a larger bench, then it is. This is a larger bench. So one is a legal question. We can or we cannot. We want guidance on that. Say that this is not good precedent law. Naturally, we cannot. We're not hearing an appeal. We're not hearing a review. Nothing of the sort. That's a general question of law, and question number 1 is a particular one dealing with this particular case.
Yes.
What do you have to say on this?
My lord, even
साहब एक छोटा सा सवाल मेरा, speaking for myself, I think we have to set the history straight, क्योंकि स्टिग्मा एक फैमिली पे नहीं लगा, स्टिग्मा कुछ अदारों पर भी लग चुका है.
Yes. Yes, Your Ladyship, that is the submission, that these are the fixes which can be done. Reputational damage, both to the person, his family, and the reputation of institutions. And an opinion in that respect.
Would you like to add the country also? For instance, some people inimical to Pakistan may say, these are the kind of prime ministers you have who commit murder. I mean, I don't know, it could be considered a stigma on the country as well if we are of a different view. What do you say?
My lord, if your lordship expresses a different view, somebody may say that it shows that these are the kind of decisions which the courts come up with. But I would say that it would be to the contrary. It would show that this is a kind of country where when it is recognized that an unsafe conviction was rendered or a wrongful conviction was rendered, they are able to correct it themselves.
We go for the answer of question number 1 as a positive. It is the procedure was wrong, everything was wrong. Then whether we go for the acquittal.
No, my lord, what happens is,
if everything is wrong, then what is left?
Even in the question number 3, the word deliberate murder is mentioned in question number 3, you see?
My lord, your lordships have reframed those questions and your lordship may go by those. Your lordship doesn't have to go by the questions as framed over here. The framing over here may not be very elegant, but the submission is this a first in judicial history? It's not. My lord, the most infamous cases decided in the 20th century in the United States related to Japanese citizens.
Let's not go there.
No, I'm just pointing out.
I'll give you a practical example.
My lord.
Can I make you the Chief Justice of Pakistan for a minute? Assume you are giving a talk to the session judges of Pakistan. If session judge of Pakistan asks you a question, so this judgment, the judgment of the Supreme Court, it's binding on me. What do I have to? I have to respond to him. What will I say? Can I not give him some guideline under question number 2? It's a judgment, yes, but in my opinion this or in my opinion that. Can the Supreme Court now simply say that? This principle of law, I think, may not have been properly applied. To found your conviction on the basis of only approval is not sufficient. It does not comply with evidentiary rules. Or I should say, and then if I don't correct it, then he or she may say, then I'll follow this judgment also. So if we just leave the politics out of it, and the facts out of it also, and just focus on this aspect, won't we be going ahead?
Mr. Arun, there's a process for that in law, that there are principles that are wrongly settled by judgments, then their subsequent judgments come and overrule those principles. And that's how the jurisprudence evolves. So there is a mechanism where judgments are given later on which overrule the principles settled in earlier judgments, and that is how the world proceeds. So that's why, the question again is about 186. Otherwise, if there is any principle of law settled which is wrongly settled, I'm sure subsequent judgments would have considered that principle and said that principle is not correct, and it gets overruled.
But I will just add to that how many murder trials have been conducted by the High Court in Pakistan's history? Firstly, so you can't get a similar case. Then the second question, how many convictions were sustained on the basis of approval evidence? So we will find it very difficult, if at all there is our precedents. So, I mean, one may want to do so, but if a case doesn't come up before us, what do we do? Now the president has asked our opinion. Okay, don't forget about me. Guide your own judiciary. Guide your own high court, guide your own session judges how to proceed. Don't you think that is our duty?
My lord, my respectful submission would be yes, and for 3 reasons. Once a judgment is made and it is upheld in review, then
वो तो खत्म हो गया.
जी, वो खत्म हो गया. Now, if your lordship the government wants to raise that issue again, it can happen in a few ways. One, the government may do that if the president is so concerned, if he thinks it's an important question of law and the Constitution under Article 186 of the Constitution. Your lordships can do that, again, not in that particular case, but at times in that case, at times in other cases, under Article 184(3) of the Constitution, your lordship has that other window available to your lordships. The third is purely executive, which
184(3) कैसे meet करेंगे आप ये? Enforcement of fundamental right. What fundamental right am I enforcing here? So, it's become very difficult. Why can't we I'm just saying, I'm not saying, giving an opinion, cause correction, where do you do it? Where you do it by interpretation, you guide your subordinate courts. Who guides your subordinate courts? The high courts in the first instance, and in the ultimate instance, the Supreme Court of Pakistan under Article 189. Why you don't seem to be very convinced with this thought of mine, if you want?
No, my lord, I am absolutely convinced that in order for your lordships to give that guidance, that your lordship can read Article 186 and 189 together. Now there was a supplementary question, not asked by your lordship, but by the bench, that where is the window to open it? And there are two windows which open it. One is the window that where a judgment is affected, not on account of an allegation of bias, but on account of an admission of bias. And that's where my Lord Yahya Afridi, when he pointed out that don't condemn the institution or tar the institution with a brush or with one stroke of a brush, that is the line of distinction which your lordship will draw between an allegation of bias and an admission of bias. And where there's an admission of bias, that opens a 186 window for your lordship, read with Article 4 of the Constitution, read with Article 189 of the Constitution, that your lordships can provide proper guidance. The second will be the window of criminal law and penal law which your lordship has identified, which is that could a conviction have been rendered on the basis of the nature of evidence in this case, it being unprecedented in nature, and it continues to remain unprecedented, and therefore your lordship is providing guidance under Article 189 to all the courts, where so far they have merely looked the other way from this judgment. They can now look squarely at it and say, this was an unsafe conviction, this was a wrongful conviction. The Supreme Court itself has so held, so I am not bound by this precedent any longer.
But Mr. Makhdoom, the President has not asked about the biasness of the judges through this reference. The only question posed by the President is in paragraph 25 of the reference.
My Lord.
25 and 26.
If your lordship is looking at this paper book of the reference, this is page 1.
Main reference, paragraph 25.
It is enshrined in the Constitution. Is that the question, paragraph your lordship has defined?
25 and 26.
That is one of the prime jurisdiction of the Supreme Court of Pakistan to do complete justice. The assumption of original jurisdiction by the High Court for trial of a criminal case is a question of law, which needs to be determined by this court, particularly in the light of a universally recognized principle and a fundamental constitutional right in Pakistan pertaining to the due process. 26. At the relevant time, the Evidence Act was in field and Article 164 of Shhید was not on the statute book. The learned High Court, while conducting the trial in hand, did not take into consideration a material fact that prosecution was not in possession of any evidence of conversation between the approver and the appellant. Surprisingly, this fact was also ignored by the Supreme Court while appraising the evidence in appellate jurisdiction. My Lord, these are some of the things which are identified, but the questions remain. which are earlier mentioned, and they are there on pages 16 to 18 of this judgment. And these are of this reference, my lord. This is the first page of the reference, page 16, questions of law of public importance. The first page, paragraph 1, whether the decision of the Lahore High Court as well as of the Supreme Court of Pakistan in the murder trial against Shahid Zulfikar Ali Bhutto meets the requirements of fundamental rights as guaranteed under Article 4, Sub-Article 1 and 2.
Where are you reading from?
My lord, these are the questions
of this court,
framed by the President and sent to this honorable court.
The
page, my lord, page is 16. The reference
page 16 पे तो मेरे पास कुछ summary for Prime Minister है.
The reference goes from pages 1 to 15, and then the second item in the index is questions of law. Questions of law are formulated on pages 16 to 18.
ये तो summary for Prime Minister.
We don't have that.
That was, I think, subsequently submitted. So questions were submitted subsequently. मेरा ख्याल पूछे फारूक साहब को बताओ.
ये references are signed by Dr. Babar Awan and the President, and इसमें ये question of law है. My Lord the Chief Justice himself read these questions as well. If your Lordship will see, they are reflected.
What questions हैं?
If your Lordship see, they are reflected in your order of 2011.
The following questions have been forwarded in continuation of the reference. ये page 963 जो judgment है ना?
जी sir.
Question जो frame हुए में उसमें लिखा हुआ है.
जी सर, ये वही question. They are exactly the same as I am reading.
Today, 21st April 2011.
Yes,
following questions have been forwarded in continuation of the reference.
This is the reference.
Yes,
वहाँ से forward हुए.
and they are exactly the same as I am reading from. They are part of the reference signed by the then President Mr. Asif Ali Zardari.
जी प्रेसिडेंट की तरफ से आए थे जो इनकॉर्पोरेट हुए ऑर्डर.
जी जो ऑर्डर में इनकॉर्पोरेट हुए. एग्जैक्टली आई एम रीडिंग द सेम. दे आर फ्रॉम अ पेपर बुक.
So you are saying it can be done.
I am saying it can be done.
What else do you want to say?
My Lord, I am saying that if your Lordship looks at the jurisprudence of bias, I have submitted a detailed note on that as well. I have submitted a detailed note along with relevant case laws.
Will be.
My Lord,
you will be submitted.
My Lord, I have submitted, and I have had those photocopied again, and I am again placing them before this honorable court now.
Just one question.
Thank
you. You said that these miscarriages of justice internationally have been corrected by. So the correction has been carried out. Just an example as to what they were, and were they carried out by the courts themselves, or what was the jurisdiction exercise?
My Lord, in the case of the United Kingdom, a commission was created. For instance, your Lordship will recall that there were convictions which were known as the Birmingham Four and which were later on reopened by the Court of Appeal, that a commission was created which used to review them, and then the Court of Appeal was asked to rule upon them. In US, it has happened in a different manner. They have, in the United States, the courts have been proactive in that respect.
One was the Birmingham Four. What about the other?
The others were, my Lord, I'll give you, Lordship.
You have, are they in the materials that you submitted?
My Lord?
Are these examples mentioned in the materials?
Yes, my Lord. The materials are there. The chapters from the books are there.
So you are of the view that we can render an opinion?
Yes, ma'am.
Just to conclude, are you concluding?
My Lord, almost. My Lord, for instance, your Lordship will find in the bundle which has been given.
Which is giving it. ये हमारे पास आया नहीं है ये बंडल. शायद कहीं ना कहीं पढ़ा हो.
I've had it photocopied overnight again.
अच्छा, दोबारा किया. Very good. Thank you. और है या नहीं, हम खुद करवा लेंगे. कितने वॉल्यूम्स हैं?
एक ही है सर.
नहीं, वॉल्यूम 1A.
1A?
इसके साथ कुछ और भी होगा.
वॉल्यूम 1A तो थे.
ये 1A के बाद भी कुछ है?
ये 1A है.
अच्छा.
तो पहले होगा.
1A से पहले 1B है ये 1A?
1A के बाद 1B है, ये 1 है. हमारे पास एक है वॉल्यूम 1A.
Hello. If your Lordship will see that
Which comes first?
My lord, if the one which has comparative chart of advisory jurisdiction.
Blue one or the yellow one?
Blue one.
Blue one comes first.
Yes, your lordship will see there's a comparative chart of the advisory jurisdiction. Shows where their lordships have taken a different in matters relating to.
If it meets with your approval, एक तो आप लोग copies ले लें वो disc की.
My lord, yes.
We will see it ourselves rather than waste time in court seeing
My lord,
it.
yes.
If you want to then, anyone wants to point out something particular in that interview, they can point it out as opposed to we just keep seeing 1 hour interview on many other issues are involved. That is one aspect. The other aspect is that it will take some time to go through because a number of amicus have submitted some briefs as well. Which we want to certainly not just reject out of hand, we want to have examined them. So we want to sort of bring ourselves, rather than just reading everything in court, which takes up so much court time, we just want to just have done our, for want of a better term, homework, and then we can ask specific questions. Have you concluded or you want to say anything more?
My lord, there will be a few submissions to be made after I have gone through this unexcised disc which your lordship was pointing.
Actually, and we may also have questions of our own.
Yes,
then.
and because that will help me focus my submissions on bias as well.
Do you want to stop at this juncture or you want to continue?
My lord, I can
at this juncture.
At this juncture, I can stop now and then go stand up once you have got the disc and looked at it and focus my submissions in accordance with the disc.
आप लोग कब रखें इसको?
कहाँ पे है? किस जगह पे?
What would you propose a date? Should it be after the elections?
My lord,
because, you know, a lot of things are coming up before us now.
My lord, I was about to suggest that your lordship will have so much work pre-elections.
We are aware of it.
Which will be of a very emergent nature, and likewise.
Because we want to give this proper attention. We don't want to rush through this matter.
My lord, in particular, my lord, may I just request that since this material has been handed over, that your lordship, and particularly my lord Mr. Justice Mansoor Shah, because that's your lordship's question about the window which your lordship will have it, if your lordship may see the yellow bundle. In that yellow bundle, there is a case known as natural page. My lord, page 35.
We are very grateful that you put everything together.
This is 2012, 10 Supreme Court cases, page 1. Your lordship is kind.
Ji.
And I will not read it because I have...
What does this help us with?
My lord, it shows your lordship, particularly in paragraphs 50 and 51, the window which is available to this honorable court, in this case the Supreme Court of India, in an advisory opinion after a final judgment has been rendered by the Supreme Court of Pakistan.
And which page would that be on?
My lord, that would be pages 94, 95, paragraphs 50, 51 onwards.
94 and 95.
So your lordship wanted to know, so I just identifying these, I'm not reading
paragraph numbers?
50 and 51.
50 and 51.
My lord.
No, that's helpful.
And then if your lordship may take a look at paragraphs 56 and 57. And then paragraph 61. And thereafter paragraph 65.
51
and then paragraph 65. It can shows what the extent of revisitation in advisory jurisdiction.
No, because India has something called curative review, which we don't have.
This is not a curative review.
Okay.
This is not a curative review. This is an advisory opinion. That is an advisory opinion delivered after a final pronouncement by the Supreme Court.
Do they have the similar provision or identical provision?
Similar, very similar. क्या करें?
One of the judges is Ranjan Gogoi. What happened to him? I mean, there are some proceedings.
My lord, I'm not aware, but if your lordship may see, in response to my lord the Chief Justice's question, in the blue bundle, your lordship will see right at page 1 is a comparative chart which gives a comparison with regard to the advisory jurisdiction provisions
In the blue book.
In the blue book, your lordship will see right after the index, your lordship will find Article 186 of the Constitution of Pakistan, Article 143 of the Constitution of India, Section 53 of the Supreme Court Act of Canada, Article 130 from Malaysia, then 62 from Pakistan, 59 from Pakistan again, and Article 213 of the Government of India Act. So your lordship has a comparative chart.
Which junior of yours did this?
My lord, he's standing right next to me.
It's good that you acknowledge that.
No, my lord, work is all done by them. I just express my desires and wishes and what I want, and they are the ones who then implement that and through their industry.
अच्छा, आप लोगों को वो रिपोर्ट मिल गई शफीउर रहमान साहब की?
And we had found it from other sources, but if there is an official...
If anybody wants it, we'll provide it.
No, Lord,
there was a commission, whether it has any relevance or not. There was because we have, I've read it. It was a commission formed, and not as he was a judge of the Lahore High Court then, and he was a one-member commission who gave, I think, 35-page report.
And my lord, may I point out, as your lordship is rising in this blue bundle, your lordship may particularly look at items number, if your lordship looks at the index, items number 16 to 19. This is what's happening in other...
Item, what do you mean by item?
My lord, if your lordship takes a look at the index of the blue book,
yes,
your lordship will see each document which is filed has been itemized, whether it's case law, serial number, whether it's case law or judgments. 2 judgments from the US jurisdiction are at serial number 13 and 14.
Yes.
And then other relevant material at 16 to 19. This is what is happening in England when it comes to dealing with miscarriages of justice. And in US, it has been done through common law, where the convictions earlier recorded upheld right up to the Supreme Court. The court has reopened them. The persons were dead, but they have quashed the conviction. They said these were unsafe. And the sentences... So these were not people who suffered capital punishment. They were imprisoned. The convictions were upheld all the way up to the US Supreme Court, and thereof they've said the courts have a jurisdiction to correct errors which have taken place and have corrected them by exercising the judicial power of the court. In US Supreme Court, the US Supreme Court has consistently refused to give advisory opinion. That's the jurisprudence from day one, like the Australian High Court, whereas the Canadian, Pakistani, Indian, Malaysian Supreme Courts render advisory opinions.
Yeah, but 13 and 14 are 2 US judgments.
They are 2 US judgments, my lord, which reopen final orders passed by the US Supreme Court.
How do they do that?
My lord, they said the power of the court to issue a writ to correct its errors. They infer it from certain constitutional and statutory provisions, and they said...
Is that discussion mentioned in these judgments?
That entire discussion is in these judgments. Therefore, your lordship said you would be reading materials. I'm identifying some of the materials, and the relevant portions are highlighted.
How can we all agree on a date? If it's better, if it's done by consensus. So, like, sir, shall we do it after the elections? Because I don't know.
Sir, as far as we are concerned, it can be before elections also.
No. If you all can agree on some date, it's same to us.
So, as far as I'm concerned, my instructions are, we've been waiting since very long. So
we undoubtedly appreciate that. That's why we've taken it up. But
as soon as possible,
because
it's up to your lordship.
You can also read these things, because that will be helpful.
So, may I suggest 3rd week of February?
पहले ही 2 इलेक्शन गुजर चुके हैं नायक साहब
जी सर
2 इलेक्शन पहले ही गुजर चुके हैं कोर्स
देखिए कसूरी साहब, let's treat us, we will treat you with respect and you please don't make statements, लेकिन ये मुनासिब नहीं है। आप तशरीफ रखें ना, अभी हम सिर्फ डेट की बात कर रहे हैं, ये हर कोई आके तकरीर करना लगता है। वही तो ठीक है ना, तो रिलैक्स, इज अ प्रेसिडेंशियल रेफरेंस, वी आर हियरिंग यू एज अ मैटर ऑफ कर्टेसी, वी आर नॉट वी मे नॉट इवन हियर यू, देखें, सो वी आर एक्सटेंडिंग यू मैक्सिमम कर्टेसी। अभी सिर्फ बात है, जरा सोच समझ के चलना चाहिए। खालिद जावेद साहब, आप कितना टाइम लेंगे? वो अच्छा, कौन कौन कितना लेगा? सलाउद्दीन साहब, आप कितना लोगे?
What about an hour?
So that's 2. आप कितना लेंगे? रजा रब्बानी साहब?
About 2.5.
जाहिद इब्राहिम साहब, आफ्टर 2.5 hours you will not take any time. अच्छा, और कौन रह गए हैं? नहीं साहब, आप कितना आपने भी कुछ राइटिंग में दिया हमने, आपका वो क्रिमिनल लॉ मैटर में आता है ना? ओके, वो हम पहले जरा इसको कर लेते हैं। यू आर मोस्ट वेलकम टू बी इन अटेंडेंस, so but sometimes the two things get converge together. It's sometimes very difficult to isolate everything. So we will not, it won't be that we're going to give a finding on the first part and then proceed to the next part. We were just going to hear the first part first and then the criminal part, because we don't want to do it piecemeal. It's an opinion. We can't give 2 opinions to the president. We have to give 1 opinion to the president of Pakistan. Okay.
May I submit before your lordship? Your lordship would hear all the amicus first of all, and then come to the concerned party.
I thought that is best, or if because they've come from other places, we want to relieve them of their burden, you may call it.
So then 3 of us would be left: Attorney General, myself.
If you want to go first, we can hear you first.
No, as your lordship please.
No, it's your call.
Because you already
we are happy either way, because really I think the Attorney General will be also be taking a cue from the others, because he's standing by the reference.
ठीक है सर, ठीक, that's okay sir.
नहीं तो आप बताएं, आप दूसरा तरीका कार करना चाहें, we will proceed.
What I'm submitting, what
you want to go first?
Let the amicus finish, then Attorney General, myself, and then Raza Rabbani sahab.
Then the part, then the legal heirs, yourself, Raza Rabbani sahab, and Zahid Ibrahim. And then last of all, but sir, not least of all, Kasturi sahab.
Zahid Ibrahim sahab, and then Zahid Ibrahim sahab, and then the Ahmed Raza Kasuri Sahab, because Zahid Ibrahim Sahab is representing Fatima Bhutto and
No, we leave it to, I think Raza Rabbani Sahab is senior, so I think it would be appropriate if he's heard first.
Raza Rabbani Sahab and then Zahid Ibrahim.
Yes, I think that's appropriate, unless आपस में वो फैसला कुछ और कर लें।
ठीक
तो ठीक है, तो हम लिखें जरा, ठीक है। इसमें लिखिए, at the outset, Mr. Raza Rabbani, learned Mr. Raza Rabbani stated that he represents, who do you represent?
My Lord, Sanam Bhutto.
He represents MS Sanam Bhutto, the daughter of the late Mr. Zulfikar Ali Bhutto.
Asifa and
Bhutto, the maternal granddaughter.
My Lord.
Granddaughters.
Daughters, my Lord.
नाम बताएं.
Asifa Bhutto Zardari.
How would you spell Asifa? A-S-E-E-F-A. ठीक है, and Bakhtavar Bhutto Zardari. Who's the elder out of the two? Bakhtavar. So let's put Bakhtavar's name first. उनका Bakhtavar, उनका नाम क्या है?
Bakhtavar Bhutto Zardari.
She's not married? I thought
she is, my Lord.
She's maintaining this name.
That's right.
Okay. लिख लिया? अच्छा, इसमें लिखे Mr. Zahid Ibrahim was appointed as amicus, but states that he had already been approached by
the grandchildren Fatima Bhutto,
by the paternal grandchildren of late Mr. Bhutto, namely
Fatima Bhutto,
namely MS Fatima Bhutto and
Zulfikar Ali Bhutto.
Junior.
Full stop. Be inquired from all those present whether anyone has any objection to Mr. Ibrahim representing being their counsel as opposed to amicus and none opposed, full stop. इसके बाद लिखिए Mr. Salahuddin Ahmed was appointed amicus and Mr. Khwaja Haris साहब का नाम पहले लिखें, and Mr. Salahuddin Ahmed were also appointed amicus, and they stated that they want to disclose the fact that they were counsel in the case of Khwaja Sahab. किसके counsel थे?
Khwaja Sahab's father was counsel for...
That his father, Khwaja Sahab का लिख दें, Khwaja Sahab's, his father was a counsel in...
for Masood Mahmood, who was accomplice turned
for
approver.
Mr. Masood Mahmood, who was the...
accomplice turned approver.
Who was a co-accused.
And approver.
Oblique approver in the case. And Mr. Salahuddin Ahmed stated that he is married to the granddaughter of the murder victim, namely
Nawab Ahmed Khan Kasuri.
इसमें लिखे none present object.
My lord, as far as, with due respect to Khwaja Sahab, but since his father had remained counsel to Masood Mahmood, we would be...
अच्छा वो हमने पहले पूछा था, आपने खड़े नहीं हुए, वो किधर हैं ख्वाजा साहब? आपको कोई इतराज है? ये कह रहे हैं कि he's very embarrassingly and reluctantly objecting to your...
No, it is nothing. It's okay, man. I'll withdraw. I don't need to. Right.
अच्छा ठीक है, चले ये लिख दें हम या नहीं? इसमें लिखें, would you want this recorded or would you like to withdraw yourself, Khwaja Sahab, as you want?
I have already disclosed that.
नहीं, would you want to withdraw yourself?
Why not?
Or you want the objection recorded and withdraw?
I'll withdraw myself on the ground that I was...
उनका पे लिख दें, वो withdraw कर लेते हैं.
I may just correct my note that my father was the counsel when contempt proceedings were being initiated or were being held against him. Just that bit, otherwise I withdraw my note.
जरा समझ गए आप?
Not in this case, but in the contempt
proceedings.
And then
ठीक है.
for the...
Okay, but thank you for coming.
No, my lord.
अच्छा, और सलाउद्दीन साहब का किसी को objection तो नहीं है? सोच लें. Okay, चलें. We heard learned amicus Mr. Makhdum Ali Khan. Full stop. He has also filed material comprising in 2 bound sets. Full stop. In view of the forthcoming elections and as important matters are coming to this court, and as this court would want to hear this case, to hear this matter, I don't know if we should call it a case, in detail, it should be adjourned after the elections in the second week of February.
The elections are in the second week, so it may be adjourned to the third
week. Third week, पर हम आपस में देख लेते हैं availability वगैरह. Third week of February. Chale, I think we've made good headway today, and certain clarity is coming through. So the date will be communicated, of course. Anybody wants to say anything?
It's all thank you.
इन लोगों की मेहनत का पसीना यहाँ जीना मुश्किल कर रहा है, क्या करें?